Welcome to Lawline with your host, Alan Schnorman. Mr. Schnorman is a distinguished trial attorney, author, and lecturer. Each week, Lawline will bring you the most knowledgeable experts in the field of law today. And now we introduce our guest and our host, Alan Schnorman.
Welcome to Lawline. The issue of mandatory pro bono work, that's free legal services for the poor, is extremely controversial in the legal community. The New York State Bar Association has adopted a plan calling for this increased volunteer efforts and public funding to meet this need. Today we'll look at both points of view, mandatory pro bono versus voluntary pro bono. Our guests are Victor Marrero, chairman of the Committee to Improve the Availability of Legal Services, and Eugene Souther, president of the New York County Lawyers Association. Hello, Victor. Hello, Gene.
Hello, Alan.
Tell me what this committee of yours does, Victor.
Well, the committee was appointed by the Chief Judge of the State of New York, the Honorable Saul Wachtler, in April of 1988 to examine the extent of the unmet needs for legal services among the poor of New York State and to recommend ways by which to improve the availability of services for the poor.
Now, is this both criminal and civil?
No, he specifically asked us to look at on the civil side.
Matrimonial, landlord-tenant.
Housing, matrimonial, contracts, and all of the various needs that the poor have for legal services.
And in a nutshell, what were the recommendations of your committee?
The committee found that there was a vast gap between the available services for the poor in civil matters and the demand for those services. We found, for example, and this is a report that was confirmed by the New York State Bar Association committee that studied it, that as many as two problems per family per year among the poor required legal services, and the poor did not have the services available.
So your recommendations were?
Our recommendations were that first, that society as a whole, society in general, provide additional funding for legal services for full-time providers of legal services.
That's government and foundations?
Government, basically.
Okay.
This is the taxpayer. We felt that the problem was so enormous that it reached crisis proportions and that it really had to be tackled on a societal basis.
Right.
And secondly, that lawyers themselves should do more to provide free legal services to the poor on a mandatory basis. That they should.
You said should, but you're really saying must.
In effect, yes, must, because we felt that the problem was so extensive, the need was so vast, that we could not wait until society gets itself together
Victor,
and mobilizes for this purpose.
You're saying every lawyer, it's your recommendation of your committee, that every lawyer in the state provide how many hours of free legal services to the poor?
Our recommendation was that every practicing attorney who is admitted to the bar provide a minimum of 20 hours per year of free legal services on matters that affect the poor
Gene,
on the civil side.
You're president of the New York County Lawyers Association. What's your opinion?
I say it is a societal need, and society ought to address it, and that's all of society, not just the legal profession. Secondly, lawyers are doing a tremendous amount of voluntary work and have been. I'm proud of the profession and the voluntary work that it does in a broad range of pro bono activities, including those for the poor. Many of those are unrecorded because we haven't kept track of all the hours that lawyers give. So I think it should be a voluntary program, but certainly we should step up the activity.
Well,
to that end, I should just say that the county lawyers has organized a group of county bars from around the country, and we've had 3 meetings, and we've proposed to the Chief Judge a county bar proposal where we would organize and coordinate voluntary activities and help each other with programs that are designed to meet the specific needs of individual communities.
It appears that the only difference in what you're both saying is the word must And the word voluntary, what a problem do you have with must?
The trouble with must is that you're throwing lawyers at problems where they're ill-equipped to do it. You're taking an ennobling activity and turning it into a tax. You're taking enthusiastic volunteers and making them into conscripts. Not every lawyer is suited to go into the housing court in the city of New York. Instead, you should have trained professionals who have a whole bunch of cases on the docket, not a single lawyer who comes from some large firm and goes up there for one day for one case.
Well, Victor, I'm sure you considered that. How do you respond?
We consider that at great length. First, we found that the volunteers who are out there is only a very, very small proportion of the bar. No matter how much enthusiasm the bar associations can generate, they don't reach all of the members of the bar. County lawyers, for example, Gene's organization has about 10,000 members.
In excess of a little over 10,000.
But that is only about 1 out of 6 members of the State Bar of New York who are practicing attorneys. The City Bar Association, the largest association in the state, has about 18 to 19,000 members. Again, out of a total of 88,000 attorneys who are registered. So we cannot reach every attorney through bar associations. Secondly, the State Bar Association study found that of the attorneys who are providing legal services now to the poor or who are actively providing pro bono services, they don't total more than about 10 to 15% at most, by the broadest definition. If you narrow the definition to just legal services for the poor, we get maybe about 7% of the attorneys who are providing legal services. Nationwide, the American Bar Association boasts that there are 116,000 lawyers who are doing pro bono work, but that's about 10% of the lawyers in the country. So I think to say that the volunteers, the 10% of the total, are going to shoulder a burden that belongs on the bar in general, on attorneys, I think is not a realistic statement to make in light of the crisis that we have.
How do you respond to that,
Well,
Jim?
I think that the statistics are too low. There are many services that are unrecorded. If Victor is limiting this purely to services for the poor, lawyers do a lot of things for a lot of other parts of society, and if they're mandated to do this work, they necessarily are going to have to give up some of the other things they're doing. But there are 2 defects with what Victor just said in trying to implement a program that'll get more lawyers involved, because they have 2 exceptions in their program. One is that a group of lawyers can get together and they can hire somebody to do their work for them, have a surrogate. So instead of having all the lawyers in the state involved, a large law firm could hire a couple of associates. Those associates could satisfy the requirement of all the partners in the firm, and the best and the brightest who have risen to the top of these major firms will do nothing. Secondly, they provide a buyout analogous to the buyout that conscripts could do in the Civil War, so that if you don't want to serve, you just send money. Now that's inappropriate, and it isn't getting the statistics that they want with all lawyers serving the poor.
Victor, could that be that the wealthy lawyer, the successful lawyers can pay the other lawyers or can send money in and don't have to do this work?
In fact, the exceptions that Gene refers to are an attempt on my committee's part to establish equity between the large firms and the small firms and solo practitioners. It is a recognition that small firms and solo practitioners may not be able to take the time themselves, in all instances, to provide personal services. They may not have the support staff, the associates and others to help them out, and that therefore they should have an option where they want to avail themselves of it to provide a contribution instead of personal services. The other side of that is that the large firms, again, to the extent that they have people who do not have the expertise or the interest to provide the personal services, they could do it again through this option of providing full-time services of one of their associates or associates hired for this purpose. The basis for this, again, is not necessarily the moral obligation of the lawyers to provide for legal services. That's something in the Code of Professional Responsibility. The basis that we're using for this need is the crisis that we identified exists in the legal system, in the legal profession, of all of these poor people who are not receiving due process or not receiving justice, who cannot have access to the courts to redress wrongs, established rights because they don't have a lawyer.
Well, who's representing the poor now? What about legal aid?
Legal aid in the entire state of New York has no more than about 900 lawyers. This is in a state that has, according to the New York State Bar Association study, upwards of 2 million unmet legal needs of the poor. There's no way that Legal Aid Society can provide all of the services. Our attempt is to provide for ways by which legal aid can get additional resources, either through contributions from large firms or through contributions from solo practitioners.
Victor, we have to take a break now for some announcements. You're watching Lawline. Stay with us.
There's a reason people whisper when they tell you a rumor. It's because 9 times out of 10, it's not true. Take all the rumors about AIDS. People are saying you can catch AIDS from a mosquito bite or in swimming pools. The fact is there isn't a single case of AIDS on record caused by casual contact. It's up to you. You can believe the rumors or you can get the facts.
Rumors are spreading faster than AIDS. Call your local Red Cross for the facts.
Lawyers, like medical specialists, limit their practice to certain areas of the law. At our firm, Zalman & Schnorman, we specialize in personal injury litigation. We concentrate on helping injury victims receive fair compensation, and there is no charge for our legal services unless we are successful. If you are too injured to come to our office, we will come to see you. At Zalman & Schnorman, we care about you.
And now a word from the American Lung Association. Your lungs are an incredible piece of machinery, but your lungs are also incredibly delicate. Diseases of the lung are among the most frequent causes of suffering, disability, and death in the United States. Lung cancer is now the #1 cancer killer in America among both men and women. Chronic bronchitis and emphysema are marked by chronic obstruction to the airflow. Among chronic diseases, asthma is the leading cause of school absenteeism. Yes, TB is still with us. In the past year, over 22,000 Americans have contracted TB. Lung trouble can come from the air you breathe at work, but thanks to the American Lung Association, you can breathe a little easier. They're working to fight all this lung disease. Your lungs are a miracle. Take care of your lungs. They're only human. And if my lungs weren't in great shape, I couldn't have said all this. The American Lung Association. The Christmas seal people.
Hello, you're watching Lawline. I'm Alan Schnorman, your host. Today's topic is mandatory versus voluntary pro bono work for attorneys. That's attorneys giving work to the poor, free legal services. Our guests are Victor Marrero and Eugene Souther. Gene, well, how do you answer Victor?
Well, first of all, I'd say that I'm not satisfied that there's a crisis that suddenly has developed and therefore would justify the inefficiency and the inappropriateness of throwing troops of lawyers at problems who are untrained to deal with them. This is a problem that's endemic to the society, and the society should respond. If you take a look at how much the federal government has been giving to the Legal Services Corporation, the amount of money has gone down substantially, not only in dollars, but in real dollars. And the heart of the problem is that beginning frankly, and not to be political, lawyers on both sides of the aisle agree with this. When the Reagan administration came in, they did everything in their power to eliminate the Legal Services Corporation. Only through the efforts of voluntary bar associations such as ours and the City Bar and others putting pressure on Congress were we able to maintain a level of funding. What ought to be done is funding ought to be reinstituted. The pressure ought to be on that for society to meet what is a societal problem. Secondly, I think Victor's approach doesn't give credit to the work that's being done by single practitioners and lawyers around the state that is not recorded, that is being done constantly, where judges ask lawyers to help people, where local bar executives ask people to help people in an area of their specialty. Plus, there are a number of county bars that have very active pro bono plans, which we've recommended to the Chief Judge be used as the models for county bars around the state.
Well, Victor, he's just said there is no crisis.
I think that goes against the New York State Bar Association study. The study clearly documents that there's an unmet need of vast proportions. I don't think any bar association that has examined the issue has come out and said otherwise. And in fact, it is the recognition that this crisis exists that has gotten the bar associations around the state now energized to try to do more. But
What I'm saying is this is not a brand-new crisis. This is a societal problem that has been around for years, and society ought to address it.
But the fact is, Gene, that it has been around for years and years, and society has not addressed it. And we, in our committee, have reached a point at which we're saying we cannot wait anymore for society to address it. We believe that it's unfair to the people who are being denied legal access to the courts, who are being denied homes, who are being denied public benefits because they don't have legal assistance to exercise the right. All of this should not happen while we as attorneys who have the responsibility under the Code of Professional Responsibility to provide public services are not doing so.
But Victor, you've already stated that an attorney, if he wants to, can buy out, can literally send money to, I assume, a committee or to the fund and not use these services. Well, what happens to that money?
Well, our effort there is to make sure that the people who are providing full-time legal services, like Legal Aid Society or the Community Action for Legal Services, the anti-poverty programs, have additional funds with which to hire full-time legal services.
Gene says that should come from the government.
It is coming from the government, but at too low a level. As he indicated himself, the government, in fact, on a federal level, has been trying to eliminate the programs, not provide more. For the last 8 years, there has been cutbacks to a point where they're providing less money now than they did in 1981. So how long can we wait before we say that this crisis is becoming a crisis in our own society?
But is it appropriate then for the state to say, when the state isn't sending money and the city isn't sending money, is it appropriate to say that we should impose a tax on one segment of society, to wit the lawyers? When there was a problem about providing medical services to the poor, we did not impose a mandatory requirement on doctors. We passed Medicare and Medicaid. Why do we select lawyers to impose what is really a secret tax? And quite frankly, why not electricians? I mean, one of the arguments that Victor has used is people, whether we have a license. Well, why not electricians? Why not plumbers? They could do wonderful things for poor people. Why not real estate developers? Why isn't something being imposed on them?
The reason is that the crisis exists in the legal system, and we as lawyers are licensed exclusively to deal with the problems of the legal system. They're problems that only lawyers have the skills, the talent, and the ability to address, and it is a privilege and a license that we protect very, very jealously.
Well, I said the crisis is not just in the legal system. The crisis is in the homeless, in homes being available, in repair of homes, in all of those things. And frankly, Victor, and you and I have discussed this before, there's a vast number of lawyers who are not equipped to go to court and not equipped to go to housing court.
And we don't say that they should go to housing court.
They should send money.
We give them an option. We say that the issue is a crisis in the legal system, and we're saying to lawyers, each should do a little bit to make it better.
Either send money or give you services.
Either provide services or provide a form equivalent to services,
but the
which
services,
could be a monetary contribution.
But the services that they have defined so narrowly that if someone wanted to serve and help a community board, if somebody wanted to serve on a panel for battered wives, that wouldn't count. There are countless lawyers giving untold hours of that sort around the state. None of that would count because the definition that this committee has come up with is so narrowly prescribed that unless you actually go out and represent an indigent person in a court proceeding, which some people are quite willing to do and enthusiastically do, unless you're prepared to do that, then the option is to send money.
However, I think Victor realizes that. However, what he's saying is your organization, although doing good work, and the city bar, although doing good work, only reaches a segment of the legal population.
A very small segment.
And he's trying to reach the entire 88,000 lawyers right here.
And we've talked about that. I had a meeting at the county lawyers just yesterday with the county bar leaders from around the state. We discussed that very issue, and we're going to try to reach out to all the lawyers, doing so with various publications, not only through our own publications, but others, to embrace them and incorporate them into the programs that we're going to make available.
I'm going to get Victor's opinion on that right after this break. You're watching Lawline. Stay with us.
Taught me to steal and to pitch. Today I struck out 7 and stole home. I think Dad would have been proud. Coach was. He said he wished Dad had taken as good care of himself as he did of me and Billy. Billy won't talk about it, and Mom can't stop crying. I don't know what it's like to have a heart attack, except I can see it hurts. It hurts bad.
You can help prevent heart disease. We can tell you how.
If you are injured in an automobile or any type of accident, you may have the right to fair compensation for injuries, pain, and suffering, including loss of wages. So if an accident leaves you disabled or unable to return to your job, put our law firm, Zalman & Schnorman, to work for you. There is no charge for our legal services unless your case is settled or won. Call Zalman & Schnorman, who is specialist in personal injury litigation.
My father, Gordon McCrae, was one of the biggest stars in musicals. He was also an alcoholic. When I was little, I thought I could stop my dad from drinking. But only the alcoholic can do that. And finally, my father got help and stayed sober the last 7 years of his life. I was so proud of him. Alcoholism is treatable and preventable. Be alert to signs that you might need help, especially if you're the child of an alcoholic. For information, call the National Council on Alcoholism, 1-800-NCA-CALL.
Hello, you're watching Lawline. I'm Alan Schnorman, your host. Today we're talking about free legal services for the poor, and who gives it. One Bar Association committee says it should be voluntary. One committee, appointed by the Chief Judge of the State of New York, Saul Wackler, says it should be mandatory for lawyers. Let's listen and find out. Victor, how will this come about? Does it have to be passed by the legislature? Can the Chief Judge have authority just to say all lawyers have to do it?
Our committee examined that issue very closely and came to the conclusion that the Chief Judge has the authority under the judiciary law and the state constitution over the administration of justice in the state courts, and that it could be done by rule of the Chief Judge in the Court of Appeals. It could be done by legislation. It could be done by perhaps amendment of the Code of Professional Responsibility.
Well, how is it going to be done is what I'm really asking.
Our final report has not yet been given to the Chief Judge. Once we give it, the Chief Judge will have to decide whether he wants to...
Give me your best opinion. What do you think is going to be the tack?
Well, our recommendation is that the Chief Judge consider doing it by regulation of the court rather than by legislation or by the Code of Professional Responsibility.
However, Gene, you represent 10,000 lawyers, and I'm sure if you're against it, what are you going to do?
Okay, first of all, I want to emphasize that we applaud Chief Judge Wackler for focusing the attention of the bar on this problem of the unmet need for legal services for the poor. We think the committee has done a very nice job of looking at it and causing us to focus. However, their solution is wrong. We have not, there is a serious question that a lot of lawyers have as to whether the Chief Judge has this authority. We have not looked into that because, frankly, we believe that a voluntary program is the right way to go, and we are hopeful that the Chief Judge will recognize that the activities of the voluntary programs of the county bar and the state bar will be the alternative he will choose, and therefore we're not going to get to a confrontation.
I understand, but let's assume January 1st, 1990, the Chief Judge just say, pro bono work, mandatory. What is your organization going to do?
I'm doubtful that our organization, although we have not addressed it and I would have to get my board to consider it, I'm doubtful that our organization would want to go to court and take on the Chief Judge on that question since he's well motivated. I'm confident, however, that there are lawyers all over the state who will be eager to do it and will do it. So the issue will be addressed.
Victor?
Well, there certainly are enough lawyers out there who would oppose the plan, and certainly to the extent that litigation is a way of avoiding the issue, they would do so. We are equally confident that if that came about, that the plan would be upheld.
Yeah. I have my doubts, frankly, as to whether the Chief Judge has that authority, but as I say, rather than look into it in a negative way, our association and other county bars are doing this in a positive way, since we all embrace the idea of pro bono. It's just a question, should we be conscripts or willing volunteers?
Victor, who's going to administrate this program?
Good question.
We suggest that the plan be self-administered, that it be based largely, at least initially, on the integrity and good faith of lawyers reporting on a biannual basis when they submit their registration statements, their compliance with the rules as set forth by whether it's the court or the legislature, whoever. But we believe that at least through that mechanism, we eliminate the fears that we're going to set up enormous bureaucracies and new administration to
Victor,
do
let
this.
me ask you something. There's somebody in their living room now, or will be sitting there in 6 months or a year when this plan may very well become effective, and they need a lawyer, and they cannot afford a lawyer. Well, how, if it's going to be voluntary, how do they know which lawyer to go to who will take their case for free?
If it's voluntary, they can go to the bar associations. Some of them will probably set up some form of referral programs.
The bar associations may be opposing you.
You said if it's voluntary. So I'm, in effect, answering Gene's question.
That's right.
Okay.
Under our program, any person who would need a lawyer could go still to the Legal Aid Society, and the Legal Aid Society would have greater resources with which to provide these services. They can go to the anti-poverty programs, which also will have greater resources.
that's
They'll
basically what
have
Gene said.
more money, they'll have more volunteers.
The point they're bringing out, you said, well, a lawyer every year will fill out a document that says, well, I spend 20 hours doing this, that, and the other thing. What I'm saying is for that client there who needs the lawyer, how do they know which lawyer to go to if it's mandatory, but if it's self-fulfilling by the lawyer just writing out who he worked for?
Because under our program, the lawyers would either go to the Legal Aid Society and say, I'm volunteering. Each Legal Aid Society has a volunteer division which handles...
The lawyers will literally work under the auspices of the Legal Aid Society?
Yes, they do that now.
And what they'll do is spend their 20 hours a year being trained, and the Legal Aid Society and CALS, instead of using their limited resources to serve the poor, they'll be spending that time training lawyers who aren't familiar with going to court how to go to court.
But Gene, they do that now. And we spoke at great length to CALS and to a Legal Aid Society. They're not saying that it's a burden. In fact, they welcome the idea of having additional volunteers through our program and having the additional dollars through the monetary contributions with which they could hire people to train and people to provide full-time services.
Well, they certainly
Victor,
welcome the dollars.
There will not be a separate organization, either under the Office of Court Administration or the Office of the Chief Judge.
Well, that's one of the alternatives that they've suggested.
We are saying that at some point there will have to be some form of additional authority to keep track of the registration statements. They'll have to. There's no question that.
What about where the money goes to? All the attorneys who are going to buy out, which I'm sure will be substantial, or maybe substantial.
Rules and regulations would have to be issued eventually by the
committee
authority.
has not addressed
we
that.
did not go into those kinds of details because we think that the most important thing now is to get through the idea of the concept.
And then you develop a bureaucracy and to manage that money, and who's going to manage it, and where is it going to go. And frankly, what concerns me is that the whole question of disciplinary proceedings against lawyers, because a lawyer may not have done his 20 hours.
That's exactly what my next question is.
And then we're going to have lawyers up on charges because they didn't go down and handle a housing case. And that's the wrong way to address a problem.
I think it's an unfair characterization. We don't impose an obligation on any one lawyer to report anywhere. The lawyer has an option under our program to either volunteer services or make a contribution.
This is your summation, Victor. What do you want to say in the last moment we have?
And we have each lawyer would have the ability to decide which way to meet the obligation.
Gene?
Volunteerism is the way to proceed. I'm proud that what lawyers have done has been very helpful to society. We ought to be given the chance with an effective, organized volunteer program to meet needs as they exist.
Eugene Souther, President of New York County Lawyers Association, Victor Marrero, head of the Saul Wachtler's Committee on Pro Bono Work. Thank you both for appearing on Lawline. This is Alan Schnorman, and as always, thank you for watching Lawline.
You have been watching Lawline with your host, New York trial attorney, author, and lecturer, Alan Schnorman. Mr. Schnorman will be back with you next week at the same time. If you have any questions or comments about this week's program, please write to Lawline, 27th floor, 63 Wall Street, New York, New York, 10005.